Susan Pearlstein. I'm the supervising attorney of the Family Law Unit at Philadelphia Legal Assistance. We provide a lot of pro se litigation assistance to low-income Philadelphians who are going through domestic relations court in either custody, support, protection from abuse, and divorce. The best interest of the child is what the court is supposed to consider when making a custody determination. And several years ago, the custody statute in Pennsylvania was amended with a list of 16 factors that the court is supposed to consider when determining custody. The three most relevant factors that the court might be considering are past and present domestic violence or any kind of an abuse. Which parent is more likely to encourage and permit frequent and ongoing contact between the child and the other parent, the non-custodial parent? Which parent or party has been acting as the child's primary caregiver? The factors are weighted by the factors that would affect the safety and well-being of the child. That's the ultimate goal, is to do what's in the best interest of the child, what is going to promote the child's health and well-being. So that means spiritual, emotional, physical, mental health. The one factor that I think is really important is the history of abuse. So if there's been past child abuse or abuse between the parties, domestic violence and interpersonal family violence, the court really should consider that, and that's one of the main factors. Proving past abuse is always very difficult. Most people don't have a lot of physical evidence of their abuse unless it was very severe physical abuse and they ended up needing medical care. And in even those circumstances, often people are so afraid to disclose what's going on in their home and to disclose that, yes, this black eye or me falling down the stairs was because of abuse, that they'll make stories up because they're scared to tell. So oftentimes there is no extrinsic evidence. It's all the person's testimony, and it's kind of, he said, she said kind of thing. But if the person who has been the victim of any kind of abuse or domestic violence in their home, medical records are really helpful. If there's any bruising, and if they have marks on their body, like bringing pictures of those marks is really important, so to document the abuse as it's happening. If they've gotten protection orders in the past, and often people go get protection orders, they'll apply for one and file a petition for a protection from abuse order, but then not follow through because of many, many reasons. They reconcile, they're afraid to go forward, they're afraid of losing their kids, they're afraid of losing, there's economic pressures, there may be threats of deportation if they're undocumented, and all these myriad of reasons why they might not go forward. And then sometimes the court will say, well, you filed a protection order, but then you didn't go through with it. It couldn't have been that bad. So it can kind of work for or against you in certain circumstances. Having witnesses is really important, and you can't bring in a whole slew of witnesses to your custody hearing, but having one solid witness who can say, I heard him threaten her, or I saw her hit him, or something like that would be really relevant. And if it is abuse of a child, then documenting that child abuse is extremely, extremely important. If you suspect child abuse, the court is going to want to know if the Department of Human Services was contacted, and if an investigation was done. And if so, what were the results of that investigation? For some people, they don't want to contact DHS. They don't want them in their lives. They're afraid that if they come and check out their abuse allegations of the other parent, then they're going to see that, maybe their electricity is off right now because they couldn't afford to pay the bill. Or, each child doesn't have his or her own bed because they can't afford it. So for some people, it's not as black and white as, it's saying, I'm going to report this abuse. The custody hearings are very short unless you ask for a long hearing with a special motion. The hearings are basically 20, 30 minutes. Sometimes the court will give you a longer time if you need it, but the court is going to expect you to kind of go in and out, in and out. So you really have to limit your evidence and your witnesses to what is really relevant in your case. When looking at the factor of which parent is going to encourage and permit an ongoing relationship with the other parent or the other custodial person, sometimes the court will just look at the history. Have you allowed the other parent to maintain a relationship? Are you not following a current custody order, and does the other side need to continually file for contempt because you drop off the child late, or you don't drop the child off at all, or you don't show up for exchanges, things like that? That can really, really hurt a parent's case. Because in Pennsylvania, before there's a custody order in effect, parents have equal rights to the child, and a lot of people don't understand that. So even if child's been living with mom for 5 years, and dad takes child out for the weekend and decides not to bring child back, if there's no custody order in effect, the police or anyone else that mom can go to seek help in getting the child back are not going to assist her until and unless she goes to court and gets a custody order granting her custody. So when we explain that to people, sometimes people have to make this decision about, well, am I going to look bad to the court if I don't give the other parent custody of the child while there's no custody order? I don't want to look bad for the court, and I really don't want to stop the other parent from having custody. Yet I'm afraid that if I give custody to the other parent, if I let the child go for the weekend, that the other parent might not bring the child back to me. So in circumstances where one parent is not encouraging and permitting frequent and ongoing contact, you need to have good reasons for why you're not doing that. And if your reasons are legitimate, the court should listen to your reasons. You should be able to explicitly say what your reasons are. For instance, you're afraid because the other parent has physically abused the child in the past, and so you were not allowing the child to go with that parent because you're fearful of future abuse. Maybe the other parent has a drug and alcohol problem, and you're concerned about that. Maybe you weren't allowing the child to go with the other parent because they didn't have proper sleeping accommodations, and you're worried about where's the child going to sleep. Maybe you're worried about who is living in the home with the other parent, and you're afraid to send the child to that environment. So whatever your reasons are for not encouraging or permitting or allowing the other parent to have a relationship with the child, do at least the minimum. If you're afraid of overnight visits, do supervised day visits if you can safely do that. But if you're not going to do it, then you need to be prepared to explain to the court why is it reasonable that you have been acting in this way. One very important factor I mentioned is who has been the primary caregiver to the child or children, and the court is really going to look at that. So oftentimes it's really hard for pro se litigants to prove that they've been the primary caregiver. Some ways to do that are show who's been dropping and picking up the child from daycare or school, who's been taking the child to doctor's visits and dentists. A lot of times it's just going to be testimony. This is where witnesses can come into play as well to say, I've been around mom. She's a really great parent. When mom and dad lived together, mom was the one who took the child to all the appointments. Mom is the one who did X, Y, Z. Oftentimes, I would ask things of the other side if I'm trying to show that they were not a caregiver. What are the child's favorite foods? What size clothes do they wear? If they don't know the answers to those questions, it kind of can show like, maybe you're not really caring for the child. A lot of times it really just is like the testimony of the parties. But you can testify, and the court's going to look at when the child was a baby. Who got up in the night to feed the child? Who got up in the night when the child was crying? Who took the child to doctor's appointments? Who's the emergency contact? Litigants can bring in documents to help prove that they've been the primary caregiver, such as doctor's records to show mom brought child in, mom called because child was sick, and each time that the child was brought to the doctor, which parent was it that was here? They can bring in school records. Sometimes we can get teachers or guidance counselors to appear, or maybe appear by phone, which is also something that people should know about. You can have witnesses appear by phone. You just have to ask the court ahead of time. Every case is different. Every situation, every family, every child is different. So what might be really relevant in one case may not be relevant at all in another. One thing that the court does look at that's not in those 16 factors but is in the custody statute is if a parent or the party's household member has any certain convictions of criminal convictions. And if a party or household member has one of these enumerated convictions, the court is supposed to make a determination of whether or not that party or household member poses a continued risk of harm to the child. And if so, the court can order an evaluation of that person to determine if there is a risk of harm, and can order counseling if there is a risk of harm. So that list of crimes is the worst of the crimes that you can think of: murder, all the sex crimes, things like that. Also on the list are prostitution, terroristic threats, stalking, contempt of a protection order, and what affects a lot of our clients and a lot of litigants in Philadelphia is any DUI or drug offense. So even if you have a 10-year-old drug offense or a 10-year-old DUI, the court is going to look at that. The court is going to look at your criminal record. Whether or not you've been convicted of one of the crimes on the list, the court looks at everybody's criminal record. If you have a criminal record for something that's not on the list, the court can still consider that. If you have a conviction of something that is on the list, then the court really has to make this determination of whether or not you're a risk of harm, whether or not you need an evaluation, and whether or not you need counseling before you can have any custody. Parties often want to bring up the negative about the other party and use that to their advantage, which in many cases that might be the appropriate thing to do, but you just have to be careful of what you bring up. If you say, I'm concerned that the other parent is using drugs and I want a drug test, which parties can ask for and the court can order, then you better be prepared to have a drug test yourself. The court can also order home investigations, and they have what they call probation officers. They're not really probation officers, they're just employees of the court, who go out and actually check out people's homes. They'll interview the people in the home. They'll look up the criminal records of everybody in the home. They'll look and see, is there electricity, gas, water, all the utilities are working? Is the home safe? Where does everybody sleep? Are there proper accommodations? So if a parent does have concerns about the home situation of the other party, they can ask for a home evaluation. A lot of times the other party will turn around and say, well, I want a home investigation of their home then. So just like with the drug test, you need to be careful what you ask for because it might come back on you as well. People need to be prepared to come to court and present themselves, and they should appear respectful to the court. A lot of times the judges are going to you don't have a lot of time to look at both parties and try and figure out, who is this person? Are you a good parent? Are you being genuine? Are you being honest? Are you credible? Should I believe what you're saying? So, the judges sort of they're forced to make these quick decisions about the litigants in front of them. And if you're rolling your eyes, the court's going to not really think that you're taking this seriously, or they're going to think that you're hostile to the other parent. If you interrupt the judge, you're going to have a problem. But oftentimes, pro se litigants don't know. They don't know how to behave in a courtroom. It's not necessarily like you see on TV. You should dress appropriately. You should not chew gum. You should be respectful and call the judge your honor. Don't interrupt the other party. Don't scream and shout when they say something like, that's a lie. That doesn't really work. You need to be respectful and calm. And it's really often really hard to be calm when you're talking about what might be the most important thing in your life, your child. The whole process can be very scary and frustrating for litigants. The court is super busy. There's hundreds of people going to court every day. To you, it's the most important thing because it's your child. And you might feel like the court is not giving you the proper time and attention that your case needs. So it's just important to remember you're not the only one in the situation. There's lots of people in your situation. The court is used to litigants appearing before them on their own. And so as long as you're respectful and speak for yourself and you're prepared and bring what you need to bring to court, you should be able to advocate for yourself and hopefully be successful.